This is Colin O'Keefe here for LXBN TV. The Kentucky Supreme Court recently ruled that continued employment is not sufficient consideration for an employee non-compete agreement. Joining me now to explain the court's ruling and its potential impact on employers is attorney Rebecca Woods. She is with Seyfarth Shaw, an author on the firm's blog, Trading Secrets. Rebecca, first off, can you walk us through this ruling? What exactly happened here?
Sure. Thank you, Colin. Donald Brown had been an employee for a straw and hay seller in Kentucky for about 16 years, and out of the blue, his employer presented to him a non-compete to sign. There was no change in his employment relationship. There was no compensation offered. There was also no threat of termination if Donald Brown did not sign that non-compete. Donald Brown signed the non-compete. Shortly thereafter, the nature of his employment with his employer changed, mostly for the worse. And within 2 years, he decided to quit and go join a competitor. The competitor sued, and the procedural history is a little bit tortured, but the end result is that the Kentucky Supreme Court clarified what it takes to have an enforceable non-compete in Kentucky on a narrow grounds with regard to whether or not consideration is required. And ultimately, the Kentucky Supreme Court stood firm that consideration is required, although it re-embraced some older rulings that provide employers broad leeway in making their non-competes enforceable.
I see. And then, of course, this ruling only applies there in Kentucky, but still, what are your thoughts on the potential impact of this? What are the takeaways for employers there in the state and then also potentially outside of it as well?
So the takeaway for all employers, whether in Kentucky or not, is to make sure that your employees sign their non-compete agreements upon being employed with the employer and make express in those agreements that their employment is contingent upon their complying with those non-competes. What this Creech v. Brown case addresses is those circumstances when employers did not, at the beginning of the employment relationship, have the employee sign the non-compete. And so the question then for the employers becomes, what do I do in order to have an enforceable non-compete in terms of adequate consideration if I want to have a present employee execute the non-compete agreement? And what Creech v. Brown says is that you have to have some element of a change in the employment relationship in order to find consideration. Now, express consideration is easy. You could pay your employee. What Creech v. Brown stands for is there's a multitude of considerations the court might undertake for that change in employment. You might consider a cluster of factors such as telling the employee that they will be terminated if they don't execute this agreement, although there's an outstanding question as to whether that alone would be sufficient. Whether the employee thereafter receives pay increases and gains experience and technical expertise in exchange for their continued employment, and whether there are any other changes in the employment relationship such that the employer, after the fact, seeking to enforce that non-compete, can say, if you look at the totality of the circumstances, the nature of the employment relationship changed such that it is supported by adequate consideration. Now, to be clear, Creech v. Brown had a number of issues, subsidiary issues, lurking in it as to the enforceability of the non-compete, but the Supreme Court only addressed the very narrow issue of adequacy of consideration.
I see. These high-level appellate courts, the judges want to keep the decisions as narrow as possible, and that appears what they have done here, but still, there are still plenty of takeaways for employers. Once again, that was attorney Rebecca Woods. She's with Seyfarth Shaw. For more of her insight and insight from her colleagues as well, be sure to visit TradeSecretsLaw.com. Thank you for joining me today, Rebecca.
Thank you very much.